Lorenzo, you're good to go. We are now live on social media, Facebook and YouTube.
Thank you, Brandon. Good evening, everyone. Thank you so much for tuning in and participating in this, our probably 12th anniversary of this symposium. I want to give a shout out, and I think he might be participating with us, and give a few words to Councilman Luis Collazo. Luis Collazo invited me back in 2008 to help with this symposium. Back then, I was a newly minted attorney, and every other year, Councilman Collazo put this event together with different attorneys from our community to make sure that seniors had access to the legal community, had access to our lawyers. We have a wonderful bar, and you're going to be hearing tonight from many of them. We're going to be giving different, talking about different subjects ranging from estate planning to immigration, to real estate, to personal injury, a whole breadth of different experiences that these attorneys have had and their knowledge that they're going to share with you tonight. We also are going to have a judge who's going to be speaking with us, and we're also going to be having a police detective that is going to be discussing some issues with regards to exploitation of the elderly. I'd like to first give our the floor to Ms. Melissa Alton. Ms. Melissa Alton is the president of the Miami Lakes Bar Association, and she's going to talk a little bit about our attorneys in this great town of Miami Lakes, our bar association, and the involvement of the bar association in this program. Melissa?
Good afternoon or good evening, everyone. My name is Melissa Caballero Alton. I am the president of the Miami Lakes Bar Association. I'm honored on behalf of the Bar Association to be here with you all tonight virtually for this event. The Miami Lakes Bar Association, if you didn't know, we are a voluntary bar association comprised of many different diverse attorneys in the Miami Lakes community, which either live or work in Miami Lakes, and we practice all different areas of the law, all kinds of law offices and different setups that go into basically our members. We contribute and like to give back to the community of Miami Lakes. We take a lot of pride in our mission to give back to the public interest and raise awareness in the legal profession. And we feel especially proud and honored to be here tonight with the Elder Committee community and the town of Miami Lakes and being part of this program tonight. If you want to learn anything or a little bit more about the Miami Lakes Bar Association, I encourage you to go to our website. It's www.miamilakesbarassociation.org, and you'll find a slew of resources there, including any kind of legal help that you might need if you need to find a specific attorney in the Miami Lakes area. We are there for you, and we're happy to help you in any way we can. And again, it's an honor to be here with you tonight.
Thank you, Melissa, for those words, and thank you to the Miami Lakes Bar Association. And I forgot to introduce myself. I am Lorenzo Cobier, and I'm going to be emceeing this evening's program. I am the Deputy Town Attorney here at the town of Miami Lakes. And again, it's my privilege and it's my honor to be part of the Miami Lakes Bar Association. I encourage any attorney out there to be part of this association. It's a wonderful group of attorneys, wonderful group. We do great networking, but we also give back to the community. That's what it's all about. I'd like to turn it over now to our councilman, also member of the Miami Lakes Bar Association, Joshua Dieguez.
Hello, everyone, and thank you, Lorenzo, for the kind introduction, although I did catch that you stumbled on my name there a little bit, which was, I would think that you deal with me enough that you would get it down pat by now, but it's okay, my friend.
Wasn't sure whether to call you Joshua or Josh, sorry.
Well, I always prefer Josh. That's a go-to. And again, first and foremost, before being a council member, I'm just another attorney like everyone else and a member of the community. So I always encourage people to just to approach me with Josh. And with that said, though, I'm happy to be here with everyone tonight. As Lorenzo said, this is a long-running event. that is a great resource to the community. There's always usually great turnout, though, because of the circumstances that we find ourselves in tonight. And in this day and age, we, of course, have to do it virtually. And that may present some challenges for some members of our elderly community, but I'm sure that the town will go ahead and make sure that we publicize this as much as possible to everyone else, because I understand that we are being recorded. With that said, among the topics I hope that we covered tonight, and because it's something that I come across in my own practice from time to time, and perhaps some of our panelists can speak to it. The two most common topics I often hear about are ladybird deeds and the benefits that they provide, as opposed to a traditional will, for example, as a way of disposing of property. Medicaid planning is also another big one that I frequently hear about. Perhaps someone on the panel can also discuss that tonight. And just in general, people often, I think, they're not sure even what a will does exactly. You know, some people think that because you have a will, you don't have to go to court, but that's not really how it works. So I think, you know, shedding light on these topics and what good estate planning looks like are very important to cover. And I hope that they will be discussed and that our panelists can help out with that. But with that, I welcome everyone to this forum. Thank you all for participating. I want to thank our panelists. They're all excellent people. Many of them I know. Bibiana, good to see you. You know, Bibiana is a great up-and-coming attorney who knows her stuff. I would not want to mess with her, so I'm glad she's here. And I'm going to turn it over to you guys. You know, Lorenzo, I don't know if you want to take back the floor, but thank you all for being here. Thank you all for giving your time, and I'm looking forward to an informative discussion.
Thank you very much, Councilman Josh Dieguez. I'd like to give the floor now and yield the floor to Councilman Luis Collazo, who came up with this event many years ago. And Councilman Collazo will also introduce Ms. Dottie Wicks, who is the chair of the Elderly Affairs Committee. Councilman Collazo.
Thank you, Lorenzo, and thank you, Josh, because I would tell you, just like you and everybody that we have represented here from the Miami Lakes Bar Association, while this theoretically came up through the Elderly Affairs Committee when I was chair, we would not be able to do this without the work of our great bar. And each and every one of you, Audrey, everybody here that's representing the Miami Lakes Bar, we're a better community and our seniors are better served by the time that you guys put in. So I just wanted to thank all of our bar members and all the attorneys and judges that have taken time out of your busy schedules to help us out. As Lorenzo said, at one point in time, I had the opportunity to do the great work that this young lady is doing. And this committee is in great hands because of her leadership. And she is on the forefront of helping seniors throughout our community, whether it's making sure that they get a meal, whether it's sure that their social needs are being met, or whether it's just reaching out to a friend in a time of need. And it's a great honor to serve alongside with her. So it's my pleasure to introduce the chairwoman of the Elderly Affairs Committee, Ms. Dottie Wicks. Dottie.
Thank you so much, Louis. I appreciate that. I just want to thank everybody that's on the committee here tonight, and thank you so much for coming. I know there's a lot of effort and time that's put in this. It's something that's really needed from our seniors. I hear it all the time. And when this was brought to my attention, I was really happy to do it. We had discussed it a little bit in our committee, and we're getting ready to vote on it. And then Lorenzo called me and said, we got it set up. So thank you so much for all your efforts. Really appreciate it. And I appreciate all the seniors I see that are on the line to ask questions. Thank you, and have a good day. Good evening.
Thank you, Dottie, for those words. Thank you to the Elderly Affairs Committee. Thank you to our councilmen. Thank you to everyone, all of our council members who fund this event, to make sure that the Elderly Affairs Committee has the funding and the membership it needs to serve all the seniors of our community. And that's the great work that you do. Right now, Dottie is busy in making sure that seniors have meals, and she's busy out in the community and making sure that even though they're quarantining and they have to keep safe, that they don't lose touch of us, you know. And this is one of the things in the outreach that's so important, to make sure that even though people are quarantined and they're socially distanced, doesn't mean that they can't be social, and that's really important. So thank you, Dottie, for all your hard work. And without further ado, I'd like to introduce our first speaker. Here in the town of Miami Lakes, we have a phenomenal police department. We count on our detectives, on our police major, Javi Ruiz, on our Sergeant Soto, and their corp of officers and detectives. And one of the things that they look after is our senior population. We have a large senior population here in the town of Miami Lakes, and seniors are vulnerable to being exploited. That is one of the biggest crimes here in Miami-Dade County, are crimes against the elderly. And so how to avoid that, how to spot that, we have with us today some of our detectives, or one of our detectives, who's going to discuss that a little bit more. And I'll yield the floor to our detective.
Good evening, ladies and gentlemen. How you doing? The biggest scams we're having now with the elderly, it's basically people trying to pass by workers of AT&T. Everything's done through the phone. They're saying, you know, they work for AT&T, Bellsouth, or maybe your car dealership or anything, and they're saying, listen, we're gonna disconnect your service, or you're gonna lose your vehicle, or you're gonna be thrown out in the streets if you don't deposit a certain amount of cash or money via either a wire or a transfer to an account. Just remember, keep in mind that anything like that, either Bellsouth or AT&T or anybody, they will contact you via mail. They'll never make a phone call. They'll never tell you, listen, if you don't pay your bill, we're gonna disconnect the power. They'll always send you a bill. They always send you a bill through the mail, and this is the way that you could verify if it's a scam or not. The second one, the biggest one we're seeing now, it's they're saying either they're attorneys or police officers, and that either a family member of yours, it's in jail, and if you don't wire a large amount of money, they're gonna be in jail for a long period of time. And that the elderly are going either to Publix or CVS, and they're wiring large amounts of money. And when they find out, it's a scam. Just remember, anytime that somebody's arrested in your family, or they've been in an accident or anything like that, police will always respond to your house. They're always gonna try to make contact with you in person to let you know if your family member has been in an accident, if they have been arrested, or any medical emergency that happened in the street. So if you get any phone calls stating, listen, wire us some money or anything like that, always double check with your family members. There's other scams that they're even making phone calls saying that they kidnapped one of your family members, either a grandchild of yours or a daughter or anybody close to you. And if you don't wire or send them a large amount of money, okay, you'll never see them again. And obviously the elderly are falling for these scams, and they're wiring the money or sending the money via mail, or sometimes they're even asked to go to CVS or Publix and buy gift cards and give them the information of the gift cards over the phone. So this way they're able to use whatever money you have inside those cards, and that's not traceable. You know, it's very hard for the police to trace that money. So it limits us on trying to find those people. So always verify, call your family members, call a friend, and ask them, you know, if in reality somebody has been kidnapped, that's, you know, either your grandchild or your daughter or anybody like that. The next one is basically the taxes. They're calling and saying their IRS that if you don't pay for the whatever amount they ask for, you're gonna lose either your property, or they're gonna come and take away whatever you have. Okay. Always remember that the IRS, if they're gonna make contact with you, it's always via mail. They're never gonna make a phone call to you. They're never gonna tell you, oh, you need to wire us some money. You need to go in the morning to the post office and mail a check to this address. Don't fall for that. Always remember that anytime somebody's gonna make contact with you, it's via mail. And those are the biggest things that we're having now.
Okay. Officer Garcia, what we'll do is we'll go ahead and we'll open the floor to see if there's anybody out there that wants to ask questions, or if any of the panelists want to go ahead and ask questions of Officer Garcia. Is it officer or it's detective?
Detective.
Detective
That's fine.
Garcia, I apologize for
That's
that.
fine.
Of Detective Garcia, go ahead and unmute yourself and let's ask Detective Garcia some good questions. Okay, I'll ask one. Detective, in your experience, how many do you find it that it's often that here in the town of Miami Lakes, you have one of the things that I've seen in my career as an attorney is folks who are caretakers, people who are in the house with the elderly, taking care of them. The elder person perhaps has some disability, perhaps either physical or mental, some dementia. And there's that opportunity for exploitation where they may ask them to sign a document or to do something. Is that something you've seen in your in your career? And also, what are the signs that a person might be being exploited in that sense?
Yes, I have not seen it here in the town, but I've seen it somewhere else where the elderly, they're being told that they need to sign paperwork or they need to sign checks towards them because one of the other family members, told them that if they don't sign up over some money, they're not gonna be able to take care of them anymore. So most of the elderly, citizens we've had, they sign over. I've seen $8,000 checks, $10,000 checks, because they're afraid. I guess they have that impact with them, that connection with the caregivers, that they try to do whatever they can just to keep them. And at times the elderly, they don't contact the family members to see if it's true or not. They don't follow up on it because they fall for it. They fall for the scam.
Anybody else? Anybody else can ask any questions you'd like from the audience or from the panel, our panelists.
Maria, I see you have your hand up. You can go ahead and unmute yourself and ask any question you like.
Yes, I have a question. We received a phone call from a person in regards to a collection from FPNL. I said, I have to take your number and call you back. They did give me their number. When I call back, they said they have different prompts, like dial 1 to make a payment, dial 2, whatever. And then I call FPNL and I told them and I gave it the information. I guess I should have called somebody in the police department maybe, and not FPNL to give him that information.
Yeah, always try to contact us first because we kind of follow up on all that. We have special units that follow up on all these things. That's one of the biggest scams we're having towards the elderly and also towards businesses, where they're being told that they need to transfer money right away, or they need to send a check, and or their power is going to be cut off or anything like that. So what they want is for you to call, give them they're going to ask for your social, they're going to ask for your address, they're going to ask for everything, credit card number, the date on the expiration date, the verification code on the back. So what they do is they go right away and they use your account, or they'll access your account and take out whatever amount of money that the bank allows them to take out. So always verify. Just remember, any company is not going to contact you via phone. A lot of it is happening now with like Amazon, AT&T. There's a lot. They just make an account and they just want you to provide all your information to them. And like you said, they'll give you a number for you to call back, and you have all those prompts. Just always verify. Always call. You did good by calling AT&T, but you could have also reported it to us, so we could have followed up on that.
Yeah, I think it would be better to call you instead of, they might not do anything. They're so busy. Yeah.
Right.
Okay, thank you.
You're welcome.
Detective, and we have somebody just send me a text asking, how do we report these calls? Is there a telephone number that you can provide?
Yes, if you call 911, that's more of an emergency number. You could call 305, the number 4, and the word police. If you see the little numbers on the phone, and that's the non-emergency number, and just request a police officer to respond to your house. And then once they get there, just let them know what's going on, and then provide the phone number that they called you from, and everything, and who you spoke to, if they provided you a name and everything.
Chair Wicks, do you have a question?
Yes, I do. If you know know someone that is not physically, but mentally taking control of that person, would that be the police or would that be another number? Because like I recently had a friend that her caretaker was getting her to buy everything, and she made her believe that she could not do without her. And we finally got it taken care of. But if you see something like this, would that be a police situation, or is there another number that you'd call for that?
Yes, you have to call us, and then we make the initial report. Okay, the initial contact with you, and then we'll distribute that report to the correct branch within the department, and they're the ones that keep following up. Either
Okay.
whether it's DCF or it's domestic or anything like that, they'll follow up. But no
Okay,
matter
thank
what,
you.
you always need that initial report from the officer.
Detective Garcia, thank you so much for spending your time with us. I know you're about to go on duty. Please be safe, and we wish you all the best.
You're welcome. Take care, guys.
I'd like to go ahead and introduce our first speaker of the evening. It's going to be first attorney speaker of the evening. It's going to be Ms. Stephanie Cruz. Ms. Stephanie Cruz is a local attorney. She is a member of the Miami Lakes Bar Association, and she is going to talk to us a little bit about estate planning 101. And without further ado, Ms. Stephanie Cruz.
Hi, everybody. Good evening. My name is Stephanie Cruz, and I'm an estate planning attorney. Very proud to own my office here, my law firm here in Miami Lakes. And I'm going to be touching on something that I think is elemental to everybody. Why? Because my focus tonight is going to be on estate planning. So estate planning, a lot of people think of it, oh, well, estate planning is only for the incredibly, wealthy. I'm not a millionaire. I am blue collar, have a house, worked my entire life, it's paid off. I have a car, a bank account, and I'm married and I have 2 kids, and my estate, my situation's not complicated. I don't need to do anything. I could just sit back and I hope for the best. But I can tell you that particular person, that's a very simple situation, that person would benefit from an estate plan, and would actually benefit from coming to see me or any other professional that specializes in this, and just have a conversation with me on what they own and where they want it to go. Because in the state of Florida, the legislatures know that people really don't like talking about death. They don't really like talking about, passing away. So they kind of created a one-size-fits-all situation where the state of Florida decided where your things are going to go for you based on what they think is just. And you can read up on it. It's called the intestacy statutes. It's a very, very dense chapter explaining, given this situation, this is what's going to happen and this is where it's going to go. And then you can say, oh, okay, well, then that exists. I don't have to worry about anything. But it's not that simple. Caveats change how things are going to go. And sometimes when I'm explaining that to people, their jaws kind of drop a little bit. So I'll give you an example. If somebody was married, had a child from this prior marriage, or maybe they were not married, but they had a child, and then they remarry, and then they have another child with this new spouse. So they have a child from a prior relationship and then now a current relationship. They don't do a will, the laws of intestacy will have that person's estate, or how I like to explain it, stuff, going, partially to this new spouse, partially to this child from this prior relationship. Maybe there's no communication. Maybe this child never called you, you haven't spoken to them in years. The state of Florida says this is just, okay? There are rules to, you can't disinherit certain people, this and that. But if you don't find that the intestacy statute is just for you, then that's why you should create your will. So a will is an instruction sheet to the judge. And as long as it's done with the correct formalities, then the judge, it gets admitted to the court. Okay, so if any of you have a will in your possession, maybe it's not yours, maybe it's your parents'. It's an original will and you have no idea what to do with it, just God forbid the day that your loved one passes, it's there. Well, the state of Florida requires whoever has that will to turn it into the clerk of the court where that person lives within 10 days, okay? And then that will, if there are things to be probated, is going, and it's done correctly with all the formalities, will break everything off where it needs to go based on that will, okay? So how I like to describe it to people, just because you have a will doesn't mean things are gonna magically happen. A will is like a match, okay? You give this will to the court, you light the match, meaning you get the probate attorney to file the petition, to create an inventory. This is what this person has. This is who are the heirs, the entire story of this person's life, basically, and all of the creditors. You have to publish in a newspaper. Was this person on Medicaid? Is there money? The entire life story comes out and is given to this judge with this will to kind of break it apart. Okay, send it where it needs to go fairly. A lot of times people struggle with, well, I'm the spouse, I'm the child. Why do I even have to go through probate? It's obvious I'm the spouse, I'm the child. The judge has to protect the assets and the stuff of this person. So it has to be, shown, okay, this in fact is the spouse. This in fact are the children. These children are from this marriage and not from any priors. When you get all that done, and then you get the creditors taken care of, which creditors for purposes of your primary home cannot attach. But if you have investment properties or money in the bank that are not protected by law, then they're up for grab by creditors. So this process is the probate process. This can take, and I tell my clients, and Lourdes is going to talk about this more at length, can take a while. So what I recommend is for you to understand that unless you create, this is another part of what I'm going to talk about, a trust, okay? Unless you create a trust, which is an alternative, it's a more sophisticated form of estate planning. A trust will pass outside of probate if all of the assets are named into this trust. So a trust, how I like to explain it, is like a box, okay? The box, you put your things inside of the box. The box has a very specific set of instructions by you, the trust maker, for the benefit of others, the beneficiaries. And then you name a trustee. The more standard trust that you're gonna see people have is a revocable trust or a living trust. People come to me and they tell me, oh, I want a living trust. This is a trust which is a more intimate family document. It's not public record. A will is public record. So anybody that wants to go on there and see who got what can do that. A trust is a internal document with instructions, and they have a trustee who has a fiduciary duty to make sure that he does whatever this trust maker said for the benefit of these people. This passes outside of probate. So what does this mean? If this person, for example, had the homestead had an investment property in Miami Beach, labels that this investment property is owned by XY trustee of the ABC trust, okay? When this person passes away, the trust already has these set of instructions that this particular condo is gonna go to these particular people. And you're not going to need the judge to make that determination because you already did that legwork in advance, okay? Why doesn't everybody do a trust? Well, a lot of people don't even know what a trust is. A lot of people don't even think, they think they have to be incredibly wealthy. Those are all myths. I mean, one of the things that make a difference sometimes when people come to see me, trusts are more expensive. A will is way cheaper, but you're paying for a lot of that heavy lifting in advance with this trust. You're making it a lot easier for your family in the long run. Usually with my trust, I include a pour over will. So if this person were to create this trust and then were to acquire assets, they would pour into the trust, and then the trust would have the instructions of how everything is going to go. Another thing with trust that's very important, if you have children with special needs, you can have a provision inside of this trust for special needs for this child. So he's able to obtain monies that you're giving him or her for their care, but they're also able to apply for other benefits that normally they would not be able to if they take on this inheritance. So trusts, you could do a lot of things. You can create conditions. You can say, so-and-so is to get this money when he's 35 and graduates college, and with a will, you can't do that. Do I recommend you to have one or the other? Absolutely. Definitely now with COVID times, I've been very busy with people asking me for power of attorneys, healthcare power of attorneys, and living wills. That's usually my three big ones, especially now during COVID. For you all, I recommend at least to think about or Google healthcare power of attorney, the healthcare surrogate, the power of attorney. Let's say, God forbid, you guys are quarantined, need to get something done somewhere. If somebody doesn't have a power of attorney for you and they're not on this account, they're not going to be able to move a finger. So if you have these documents in place, you have facilitated somebody to be able to help you. Because trust me, when things get bad, they get bad. I mean, and you need to have, you said, wow, if I would have done what Attorney Cruz said, I would have been in a much better position because I'm seeing it so much. So if you understand anything from what I'm telling you, at least learn about the POAs, learn about the health POAs. Promise you it'll be a big help. Another part of estate planning, but somebody else going to talk about it, very important, is the ladybird. So when you guys hear about the ladybird tonight, I want you to really hone in on that. It's very important and it will save you a lot of headache. So thank you so much. And I'm here for you guys, whatever you need.
Thank you so much, Attorney Cruz, for that wonderful presentation and explanation on wills. Now we're going to open it up to questions. Any questions that we have from the public or from the panelists, this is your opportunity to ask Attorney Cruz questions about the will, establishing a trust, the differences, the importance. The floor is yours.
Hello?
Yes.
Okay, I have a question, and it's not necessarily regarding a will or a trust, but it's regarding a warranty deed. The warranty deed of my mom's primary residence is in her name and my name with rights of survivorship. With that type of deed, the house will belong to me, or it will have to go to probate.
So Francisco de la Barra is the attorney for real estate. He can answer you that question. Unless you want me to.
Go ahead, attorney. Go ahead, Attorney Cruz. Answer the question.
Okay, so very important. So you could take title a couple of ways: tenants in common, if you're married, intestacy, or joint tenants. Usually single people that buy a house together, they take joint tenant. Why do they take joint tenant? Because it's the next best thing if one of them were to pass away. So in your situation, you're saying that you and your mom took title joint tenant. If God forbid your mom were to pass away, then the deed, if done correctly, which I'm sure it was, would have her interest flow into you.
It doesn't say joint tenant. It says with rights of survivorship, the deed.
I think it'll still work.
The same thing? Okay,
My opinion.
thank you. Thank you.
Okay. Any additional questions? This is your opportunity.
Hello?
Yes, Ms. Bell.
Hi, yes, I have a question. Just one clarification in regards to when the attorney stated the will needed to be submitted to the clerk of courts 10 days after that's 10 days after death of someone, correct?
That's 10 days after the holder of the will is alerted of the death. But in my opinion,
But not after it's been drawn up, after
No,
they've been
no.
Okay. Okay.
And in my opinion, and because I've seen litigation, anybody that's holding the will needs to get down to the courthouse ASAP. Because maybe
Okay.
somebody will come in and say, wait, I got a will, you know, and then it just turns into this entire, well, who came first, who came so. If you have one and you don't consider it to have been revoked or fake or anything, it's the legit one, you should get down there and deposit it.
Okay. My other quick question I had, when you mentioned about creditors, you mentioned, I don't know if you mentioned that if a home, do creditors have right to your home?
So so part of a big process, and Attorney Corvo can talk about this, you get the home established, if you get the home classified as homestead, which is the holy grail as far as protecting property, then that's not up for grabs by creditors. But there are nuances, you know, if it's co-owned by, or I had a situation where the gentleman, he owned a duplex and he lived in one of the units, rented the other one. So I could only have homestead on half of that duplex. So if a creditor came in, thankfully none did, but technically the creditor can claim half. So homestead, if that exemption is classified, it's not the exemption, don't confuse property tax homestead exemption. It's an actual classification by the judge.
Okay, so that leads me to one last question. My mother and I own a home together. It was originally her and my dad's home. My dad gave me his half. So now she and I are owners of the home together. Now you said don't mix up the homestead. She does have homestead exemption through the property tax, but how do we get the judge to classify the home as homestead? She's the senior. I'm not a senior citizen.
Well, that would be, Attorney Corvo can explain the process in her segment.
Okay, thank you.
Thank you.
And I want to thank Attorney Cruz. Thank you so much for being a member of the Miami Lakes Bar Association, being part of this process. You've been with us for several years and you are always willing to give back.
My pleasure.
Without further ado, let's pass to Attorney Corvo. She's going to be explaining a little bit more on the probate process. She can take a little bit from what Attorney Cruz just said, maybe answer those questions and elaborate a little bit more about what that process looks like and ways that perhaps you can avoid that process altogether. Ms. Corvo, I've had the pleasure of knowing her since I started my legal career. She is a legend here in the town of Miami Lakes. She's a member also of the Elderly Affairs Committee, as is Attorney Cruz, and she is also a past president of the Miami Lakes Bar Association. Without further ado, Ms. Corvo, Attorney Corvo.
Good evening, everyone. Welcome. I was given the task of trying to explain to everybody what a probate process is. And I'm going to try and do it in a nutshell because I have a whopping 10 minutes. So I'm going to go really fast and give you some time to ask questions. The probate process is the process whereby someone has passed away and they have assets, things. When I say assets, it could be real property. It could be something of value. It could be something, bank accounts. It could be investments accounts. It could be businesses. It could be a car. It could be a boat, anything that is only in the decedent's name. Now, when I say the decedent's name only, that means if, when they were just asking, if the house is owned by someone with right of survivorship, that is not a probate asset. Because it automatically, when you have something that says with right of survivorship, it tells the world that this automatically goes to that person, and it's permitted by the statutes to go that route. So when somebody passes away and they have assets, like I said, that are only in their name, you need to probate the assets. Now, some are very tedious, as Stephanie had explained, and some move very quickly. And it really depends on how much fighting goes on within the family. And I hate to say this, but I've seen trust get as ugly as probate assets. And I'm sure Stephanie will agree. Probate litigation is probably just as bad as trust litigation. So people fight because they don't like what they're getting. So now the probate process can be one of two. It could be intestate, which means without a will, or it could be testate, which means there is a will. So that's the two difference between testate and intestate. Now, if you have a will, the court abides by the terms and condition of the will if it's considered a valid will. Now, a valid will has to be, two witnesses have to sign it, and there's some other, it should be notarized, and then there's forms that give a presumption that it's a valid will. Let's assume that it's a valid will, and now the court appoints who the personal representative is, because in the process of preparing a will, you always name who the personal representative is. The personal representative is in charge of gathering all of the assets and making sure that they go to whoever the will says it should go to. Not difficult unless you have people fighting. Again, it's only if you have people fighting do you have like a very extended litigation and a probate process. Because if there is nobody fighting, you usually get a case open within a few weeks. From that few weeks, you then have to publish. You have to identify all of the creditors of that estate, which means, do they have credit cards? Is there a mortgage? Did they owe somebody money? Anything that they owe somebody money, or some person or company money. So you have to give that notice specifically to that person if you know who they are. And even if you know that, you have to give them formal notice, which means you have to send them a formal letter, and you have to, send it certified mail to make sure that they got it and be able to prove that they received it. But you also have to publish in the newspaper. Now, it's not in the Miami Herald. Most people publish in what they call the Daily Business Review, which lawyers read it, and hospitals read it, and bank accounts, credit card companies read it to see who died so they can put in claims. Within that 90-day period, somebody has to file a claim. Now, if there is no claims filed, then you just really have to distribute according to the will, okay? Now, there's some caveats. There's things called homestead, which somebody was asking about. Homestead says this is the place, the house, the home that the person lived in. They didn't have to live in it. They could have been in an assisted living facility for the month before, or even 2 months before. But if they didn't rent it and they had the intent of coming back, it still can be considered homestead. But what you have to do to declare a property homestead is that you have to show that the taxes were in the person's name. In other words, the person owned it. So Miami, the property appraisers and the tax collector from Miami-Dade recognizes it as their home. Number one. Number two, you have to show bills that show that this is where the person lived. And I've gotten around that because sometimes they send their bill to like their person that takes care of their books. So you can prove by, is there insurance there? Did they get, did the doctors show that that's where they live? So you have to just prove to the court that that's where the person lived. And then that house, that asset of the home is protected from all creditors. It's protected from doctors. It's protected from attorney's fees. It's protected from everything. Nobody gets money, and it goes to whoever in the will it says it is unless the person devised it. In other words, said in the will that it goes to somebody that the law does not permit it to go to. In other words, the law is not going to permit, if you're married, to give the house to your friend. You can't do that. The spouse is entitled to the homestead if they're minor children. You can't give the house, for example, to a friend if you had minor children. You're not allowed to do that either. Again, they're entitled to it going to them. So the law protects the homestead. But if you declare the homestead, then the house in yours, what they call in yours, it goes by law. It's supposed to go by a blink of an eye, but we all know it's not a blink. Anybody who practices this area of law, it's supposed to go by a blink of an eye from the person that is entitled to it upon their death. Or if not, if nobody's entitled to it upon the death, let's say if it's a single person and had a home, they can give it to, whoever they want, their friend. They can give it to a church. They can give it to whoever they want. And then you just distribute all the money, all the assets pursuant to the will. Now, if there is no will, then the law, like Stephanie said, is very specific as to who gets it. Now, the question I've been asked numerous times is, well, then the government will get it because, the government always gets it. I can tell you the government, it's called escheat to the estate. You have to be a lonely soul with no family members in existence. And the only time I've ever seen that is a Holocaust survivor, because they had no absolute family. I consider it a tree, and you know that a tree has roots and it has the stump of the tree, the major, and then you've got the branches. And in an estate that doesn't have a will, an intestate estate, you've got to deal with that tree. And that tree has all these branches, which means, well, you see, are they married? No. Do they have children? No. Do they have parents? No. Did they have brothers and sisters? No. Did they have aunts and uncles? Yes. Or some of them have died. Then you have cousins. The tree is a very large tree. When I tell you a very large tree, you just have to follow the tree and follow the branches and where it goes to. Now, like Stephanie said, it's good to have a will because, for example, I have a case where the tree led to somebody in Spain, a half sister, which my client, the decedent, had never even met because, the decedent was a Down syndrome child and he didn't have any siblings. His mother had died and his father had died, and he had this half sister that lived in Spain from the father's second marriage. So the sister acquired all the assets from somebody she had never even met. And we're talking an old person. We're not talking, a 15-year-old. We're talking somebody that was in their 50s or 60s at the time. So if you don't want that to happen, you really do want a will or a trust. Now, when it comes to creditors, they have to file and say, I'm a creditor and I'm a valid creditor. And we can then say, no, I don't think you're a good creditor, because I'm sure there's an Ana Fernandez somewhere on this call, or a Maria Diaz, or a Maria Garcia, or a Juan Rodriguez. And as we all know, that's a very common Latin name, or a John Smith, or a common name. And there might be people who come in and say, I'm a creditor. Well, you could say, no, you're not a creditor. Prove to me that this is the person that owed you money. And they then have to prove that by filing a lawsuit and saying they really do owe me. And usually they're wrong. It's usually a credit card company that just picked up, a Gonzalez name, an M. Gonzalez, and they will put in a claim hoping somebody pays them because an M. Gonzalez didn't pay them at some point in their life. So you want to make sure that, in the process of probate, that you say, this isn't the person or it is this person. And you can then negotiate with them as to the amount that's owed. The other person that you have to give notice to is ACA, which is Medicaid. Medicaid, if at any point in your life you received Medicaid, in theory, the day you die, if you have assets that are not protected, they have to be paid back. And a lot of people don't understand that because they got Medicaid when, let's say, they were in their 30s, they recovered from the situation that they were in, that they needed Medicaid, and now they died in their 80s and they had money. And so now Medicaid will come in and put in a claim and say, this is how much we paid for the services. So we do have to give notice to people, to Medicaid when somebody passes away over the age of 55. Let me see, what else? The IRS, you need to be able to, before you can close an estate, you need to be able to prove that no money is owed to the IRS. Now, the state of Florida does not have a state tax. Let me be very, very clear. The state of Florida does not. The US does. The US right now is a little over $10 million that is exempt. So you have, it's 225,000. So if you have more than that, they will charge an estate tax on the amount that's over the 10.25 million. Okay, so understand, and for a couple, it's the 10 for each person. I'm rounding down. It's the 10 million for each person. So if you're in anywhere in that ballpark, you need to immediately run to an estate attorney and do some estate planning and do some sophisticated estate planning so that you don't pay more taxes when you pass away. Now, the court will appoint a personal representative if the value of the estate is over $75,000. The $75,000 does not include the home value, the homestead value. And so what is the responsibility of the personal representative? It is to gather, to hunt, to look for, to protect all of the assets and the creditors of the decedent. From going to the bank and opening up the box that they had at the bank, from gathering and protecting and closing up the home so that it's protected. I have one right now that they're dealing with a mold issue because when the person died and they went in, there was mold all over the place. Well, you have to make sure that that value is protected. So we have a mold remediator coming in and fixing that problem until we finish probating the estate. I think, who can be the PR, the personal representative? It really can be any resident of the state of Florida. And it can be an outside resident of the state of Florida if it is a spouse, a child, a lineal, like a blood relative. It has to be a blood relative, and that's how they describe it. So it can't be a friend that you chose that lives in California. I want them to be the PR. The court won't allow it. So they have to be either a blood relative or they have to be over the age of 18. If, for example, you die intestate, then you say, well, who gets to be the PR? Well, there's a priority with that as well. You know, it's a spouse first, and then it's the heirs get to, you know, they're all on the same level, and then the majority of the heirs can pick who they choose. And I think, and like Stephanie said, you're supposed to probate the will within 10 days of learning that the person passed. I can tell you that's very rarely done, but it should be done that way. And it is not a first come, and I know that Stephanie didn't mean it this way, but it's not a first come, first serve, like, oh, I put my will first, so they get to abide by my will. The last will that the decedent made, if it is a correctly made will be the will that will be probated. So if you run to the courthouse and you had one from 5 years ago and somebody else comes and says, oh, I have a will that they did 2 years ago, the one from 2 years ago is the one that the court will look to be, will consider it to be the valid will, if in fact you can prove that it is a valid will and nobody can test it. You know, the person didn't have Alzheimer's, they weren't in a coma and had somebody, you know, write their name on it. But if they had the capacity to do the will and there was no coercion or any malfeasance done, then the newest will be the one that gets probated. So I think that's probate process 101 in 10 minutes or less.
Thank you so much, Attorney Corvo, for that. We open the floor for any questions that panelists or anybody from the public may have.
What's your name?
Hello.
Hi.
Hello.
Yes, I have a question.
Wait, let's do it one at a time. I think we had
Okay.
Mr. Javier. You have a question?
Yes.
And then
my
we'll go to
wife
you,
is gonna
Trimita.
Make the question. Ask the question.
Yes, I want to ask for my husband Javier. We've had our father-in-law passed away in March, and we've had the will and probate since March, and up until now, the judge has not seen all the documents yet. My question is, what is the standard time frame for this type of procedure? Does it take that long?
The courts are actually right now moving very quickly. I am shocked at how fast they're moving. But again, it depends what is being filed. In other words, the court doesn't really need to do much of anything. I can tell you, opening up an estate right now and getting a case number and getting letters of administration is taking 3 weeks, maybe. And then from there, you can act as the personal representative and start doing things. Now, the personal representative, it depends, again, how fast things are moving, whether you've got consents, whether you have a will, where, you know, are people cooperating? You know, I've had people come to my office, here's the will, here's the death certificate, because you need a death certificate. Here's the death certificate. You know, the family comes in together and they're all like, yeah, here, let's do it. And we've done the entire process in 6 months. Now, I just finished closing an estate that I've had 10 years open, but there was a huge fight between, they were contesting the will. There was an issue with the person that was contesting the will. They ended up in a guardianship. They had to have a special, I mean, it got complicated, and there were tons and tons of property involved, and what was the value of the property and what wasn't the value, and the negotiations and mediation had to happen. But that's a different animal. But if everybody,
I think, Lourdes, if I may, I think when people come in general, I think because I don't want the person who asked the question to feel that a probate takes 3 weeks.
No,
That's
it
not
doesn't.
it at all.
No. I said they open up the estate. I said they open up the estate and they should get letters of administration if there is no fighting.
Yeah.
Within
But on
3
average,
3 weeks.
you're seeing more or less, you allocate about 6 months minimum, maybe.
Right, to close an estate, from opening an
Yeah.
estate to closing an estate, that is 6 months. So yes, I do believe that is the case. Sorry, that's my husband that just joined the crowd here. But it really depends on how fast people are moving. Like if you can get consents from family members to say that the homestead is valid homestead, then you get consents. You know, the more people get along, the faster the process. The more people fight, I'm telling you, I have one that is 10 years that I'm closing it out. I'm in the process of closing it out now.
If I can tell you something you may not believe, but the whole problem, according to our attorney, the whole problem is due to a watermark on the death certificate. And the clerk's assistant, the assistant of the judge in Broward County, keeps putting back the papers because of a watermark on the death certificate. And no one in the family is fighting. My father-in-law did not owe any money at all. Everything is in perfect condition.
They should be able to file do they have the original death certificate? Because you have to file the original death certificate in the court.
Oh,
They
So
first
there
asked,
should not be a watermark at all on it.
they
You
first
need-
asked Broward
You
County.
need the
first-
original death certificate to file it in court. If the person died outside of the country, there are procedures that you have to go through to legitimize that death certificate here in the United States.
We
no,
need
no,
to-
he died in Pembroke Pines. See, so you.
Oh, no, so you should have a death certificate issued like a.
I want to say two things. We need to move the matter forward. So one thing I would love is, and everyone here, all the attorneys and Ms. Attorney Cruz, I didn't offer you the opportunity, but please also feel free to provide your telephone number so that people from the audience can call you and ask you any questions afterwards and have a consultation. So Attorney Corvo, if you want to give your telephone number.
Sure, my number's 305-82, sorry, I have braces. 305-827-0084, and I sound like Daffy Duck now. So it's 305-827-0084.
Okay, thank you very much.
Perfect.
Thank you.
And I want to make a comment also, because something I've heard from other attorneys that I've seen is that right now the courts are moving forward, but you've got judges working out of their houses, you've got clerks working out of their houses, you've got their assistants working out of their houses. Nobody's really in the courthouse, and everything is kind of being picked up and being processed. And sometimes the right hand doesn't know what the left hand is doing. If you've got the judge that's on the ball, maybe he's moving faster than someone else that's not. So you've got a lot of things going on because of this whole COVID situation. And Attorney Cruz, if you also want to give your telephone number and information.
My phone number is 305-698-6565. 305-698-6565.
Thank you very much, Attorney Cruz. And I'd like to go and move on to our next speaker. It's Mr. Carlos Enriquez. Just like Lourdes Corvo, Mr. Carlos Enriquez is a legend here in the town of Miami Lakes. He is a person that I hold very dear to my heart. He's a good friend and has been a mentor to me. He's going to talk to us a little bit about guardianships and incapacity. And that's what happens when the person is no longer able to make their decisions and require someone else to be able to make them. And Carlos is going to be able to elaborate a little bit more. Without further ado, Mr. Carlos Enriquez.
Thank you, Lorenzo. I think you meant a legend in my own mind. In any event, good evening, everybody. Let me begin by saying that guardianship law should be of interest to you. We're seeing more and more guardianship cases with a lot of individuals filing for guardianship cases due to dementia, Alzheimer's, and the sort. Chances are, these are statistics you can easily Google, are that you or a loved one may be involved in a guardianship matter at some time in your life. Approximately 25% of the population in this country will end up in a mental institution or an ALF at some time in their lifetime. So that being said, what is a guardianship? Well, a guardianship is a process wherein an individual petitions the court to determine the capacity or incapacity of an individual and name a guardian for that person. The guardian is the individual responsible for managing the affairs of someone who is determined by a court to be unable to make decisions on their own or manage their affairs. People who need a guardian typically have dementia, as I said, Alzheimer's disease, a developmental disability, a mental illness, a traumatic brain injury, chronic illness, or other conditions that cause limitations related to the daily functioning and decision-making, or what they usually call ADLs, activities of daily living. So if the court determines a person is incapacitated, a guardian is named. Now, before a guardianship is established, it must be determined whether the individual lacks capacity to make decisions for himself and whether he has the capacity to take care of his assets or make decisions regarding his financial affairs. A court will hold a hearing, evaluate the evidence presented, hear testimony, and review a report of an examining committee appointed by the court comprised of 3 individuals trained for this task, including a physician. The court will also review a report of an attorney appointed by the court, usually referred to as a guardian ad litem, to represent the AIP, or what's typically meant to be alleged incapacitated person. Because when one files a petition to determine the capacity of an individual, he's referred to as allegedly incapacitated. He's not incapacitated until the court determines that the person is in fact incapacitated. Now, a guardianship should always be considered as a last resort because it is the most restrictive option available to assist individuals in need of decision-making and handling their affairs. The procedure to determine incapacity and the appointment of a guardian begins by the filing of an individual who is legally competent to determine the incapacity of the individual. This is filed in the Mental Health Division of the Circuit Court, and notice of the petition to determine incapacity is served on the alleged incapacitated person and to all known next of kin. The courts are very sensitive to the alleged incapacitated person's constitutional rights, hence notice is vital. And the court then appoints, like I said previously, an examining committee to meet with and examine the individual that's alleged to be incapacitated. The court also appoints an attorney or a guardian ad litem to represent and defend and protect this alleged incapacitated person with his constitutional rights and his statutory rights. That attorney is given instruction to go and meet with the alleged incapacitated person whom he has been appointed to represent, read him the notice that the court and the clerk issued, and prepare for a hearing and submit a report to the court. A hearing is set by the clerk, and the alleged incapacitated person may or may not be present. His presence may be waived by his attorney. The judge reviews the file, hears the evidence presented and the argument of counsel, and makes findings of fact and rules if the alleged incapacitated person is in fact incapacitated and in need of a guardian. Now, pursuant to statute, Florida statutes, any of the following individuals may be appointed guardian. I shouldn't say individuals because it could be an institution. The guardians are typically any Florida resident who is legally competent, or what we call in the legal profession sui juris, any non-resident who is legally competent and is related to the incapacitated person. Lourdes touched upon this before in appointing a PR. It's a similar concept. If it's a family member that lives outside of the state and can still take care of the person by delegating duties for his or her care, the person can be appointed. Any bank, I've seen banks appointed, usually when it's a guardianship for the property to protect the alleged incapacitated person's assets. Any nonprofit, religious, or charitable organization can also be appointed, not as often as it used to be, but legally they can still be appointed. A public guardian in some counties, including our own, we have the Dade County Public Guardianship Program, or a professional guardian if there are assets to pay for them. Whichever type of guardian is appointed, an attorney must always represent the guardian. In other words, the guardian cannot represent himself unless he is an attorney. Types of guardianship. There are 3 basic types of guardianship. There is a family guardian. In other words, a person who is appointed as a family member, not a professional. a professional guardian or a public guardian, like I said before. If the court determines that the alleged incapacitated person needs a guardian and the alleged incapacitated person has a family member or friend willing and able to serve, then the court will generally appoint a family guardian, since there are no costs involved usually in those cases. If the alleged incapacitated person does not have a family member or a friend willing and available to serve, the court will appoint a professional guardian. A professional guardian receives payment from the ward's assets for their services. If the incapacitated individual does not have any family or friends willing to serve and has limited finances, then the court will probably appoint a public guardian or a guardian who will serve pro bono or for no charge at all. The two most common guardianships are the limited guardianship and the plenary guardianship. In a limited guardianship, the guardian assumes only the delegable rights specifically assigned by court order. This is done when the ward or the alleged incapacitated person is not totally incapacitated. It can still make decisions regarding his well-being, where he wants to live, voting, because if the person is declared plenary guardianship, he loses a lot of his statutory and constitutional rights, including like the right to vote, the right to where he wants to live, and so forth. But if it's limited, some of those rights do remain. The most common type of incapacitated people served in guardianships are the following diagnoses: age-related, such as Alzheimer's disease, Parkinson's disease, dementia; developmental disabilities like intellectual disabilities, Down's syndrome, and the like; traumatic brain injury like concussions or second impact syndrome injuries; and of course, mental health incapacities such as schizophrenia, anxiety, panic disorders, bipolar disorder, eating disorders, and the like. There are instances when a guardianship is not necessary, and in such cases, exploring the least restrictive option should be considered. Individuals may avoid the need for the appointment of a guardian by careful pre-planning. An advanced plan or advanced directive might include both a dual rule power of attorney, authorizing or a designated person to manage finances and personal affairs. If a person becomes incapacitated or becomes disabled, you nominate a pre-need guardian in the same dual rule power of attorney. And there's also what's called a healthcare surrogate, which is like a medical power of attorney that authorizes a designated person to make medical decisions with the individual's wishes. Now, planning and legally designating a responsible individual to make decision on one's behalf will likely limit authority in ways that are consistent with an incapacitated person's individual's preferences. Furthermore, it may also allow the members of a family to avoid the need to file court petitions, attend court hearings at what will already be an emotionally difficult time. So dual rule powers of attorneys are excellent instruments to avoid falling into this predicament. By leaving a power of attorney, during your lifetime, and you're able to do it, you designate a person you trust to make decisions for you. In conclusion, I hope you have a better understanding of what a guardianship is and the alternatives to a guardianship. Good night.
Well, don't say good night yet. We still have questions from the audience. So we'll open it up to the audience who would like to ask questions of Attorney Enriquez.
I have a question. Can you hear me?
Yes.
Hi. I have a question for Attorney Enriquez. My mom, we're actually dealing with a situation, my sister and I, with my mom, where she's getting ill, and we are in the process of getting the necessary paperwork to speak to doctors and, and act on her behalf. She's still mentally capable of, providing the signing papers and giving us authorization. But the question that I have is, because my sister and I are both involved, if she puts both of our names in a document as being equally or having equal rights to act on her behalf, how is that received in the in the case where we have to make a major decision? Like, do we both have to be in agreement, or one of our, like if one person makes a decision, it's it's equally valid?
Okay, I usually recommend that the individual name one person, and in that person's absence, a second person, making it easier in an emergency situation that could foreseeably happen, where you're in a hospital and you need to make a decision, and now your mom left it so that both of you have to jointly make a decision. Well, it requires a joint decision. And if, today with globalization and the internet and so forth, that may be resolved by Zoom or something like that. Some hospitals are doing it. But imagine about if the person in charge of the hospital or wherever it is needs both of you to be present there and sign a document. It makes it more difficult. Nevertheless, if that's what your mother wants to do, it can be done. You can do it so that one or the other can make the decision also.
Yeah, that's what I'm thinking, because yes, because it occurred to me that as things get progressively worse, unfortunately, there are going to be some tough decisions that need to be made. And if my sister and I are not in agreement, then it could become difficult for everyone. So I'd rather think, have my mom designate one person to be the main person, and then if the other one is not available, then the second person could could act on her behalf.
Attorney Enriquez, can you give your telephone number so that Mr. Naranjo and anybody else who wants to contact you can?
Sure. My phone number is 305-826-2080. And I am here in Miami.
Thank you.
We'll take one more question.
This is Tramika. I was waiting to ask a question.
Sure, Ms. Bell. Go.
In regards to the power of attorney, my situation is very similar to the lady that just spoke, where I have a sibling, and we recently got a power of attorney for my mother, and we had my husband sign as a witness, and then the person who notarized signed as a witness. And I recently had something else notarized by another notary who stated that should not have happened because the notary has conflict of interest, that she should not have signed my mother's power of attorney as a witness and as a notary. And she's suggesting that we redo it. Is that correct?
Well,
hello?
Yes, that happens with wills also sometimes, where there are two witnesses and one of them is the notary. I do it with two individual witnesses and a notary.
Okay.
The rule, at least for example, deeds, the notary can serve as a witness. With wills, the notary should not serve as the witness. The rule of thumb is the notary should not be notarizing. The notary can't notarize, obviously, themselves. So if they're serving as a witness, they can't do that. And then they can't notarize for family. So if there's any sort of conflict there where your documents have that problem, then that would be a problem.
She's not family. We just was someone that was referred to us, and my husband signed as witness, and then she stamped it and signed it as the notary. So I was told that we should redo it, and I didn't want anything, to cause any legal problems in the event that we needed to produce the power of attorney.
I think that's good advice, and it would be preferable that your husband not be one of the witnesses.
Oh, okay.
Not that there's anything wrong with that. I'm just saying that it would be preferable.
Okay.
So we need to go on to our next speaker. Ms. Bell, thank you so much for your question. Thank you very much, Attorney Enriquez. He's provided his number.
You're welcome.
And if you need to get in touch with him, Ms. Bell, I encourage you to go ahead and do so, or it's with Ms. Cruz or Ms. Corvo or any of our speakers this evening. The next speaker I'm going to present is Ms. Bibiana Potestad. Bibi, She is a dear friend of mine, and she's been helping us out for the last couple of years. And she's going to talk a little bit about personal injury and also as it relates to nursing home incidences. And so without further ado, I'm going to pass it on to Bibi. And also, I'm going to be stepping away for a few minutes and be passing on the MC to Ms. Cruz, who's going to be carrying the baton. Thank you.
Thank you, Lorenzo, for that introduction. Before I start, I just want to let you guys know that in the chat, there's people that have been asking questions. So I don't know if we've been looking at them, but maybe someone should be monitoring those. So like Lorenzo said, my name is Bibiana Podestad. I mainly do real estate, and the firm that I work at also does personal injury. So what I wanted to talk to you all about today is obviously something that has hit very close to home for some of us, especially in South Florida, where we have, or in Florida in general, where we have a huge population of seniors. So COVID has impacted a lot of assisted living facilities and nursing homes with the swept of the pandemic. So a couple things that you need to know if you find yourself or were in a situation where either you or a family member or someone that you know was in a nursing home or in an assisted living facility that obviously was either infected or affected by COVID. There are certain things that you should know because obviously there are aspects of the law that you may have recourse in. So the first thing that you should know is that liability is not automatic. So unless you bring on a case and you hire a personal injury attorney to be able to bring this forward, it's not going to be automatically presented for you, and no one's going to go ahead and get damages for you from the nursing home or the assisted living facility, which from now on I'll be calling ALF, because if not, this is going to take too long. So another thing you should know is that obviously the liability, once you hire that attorney, is based on negligence. So there's different ways to determine whether there was negligence. It's, you know, if they failed to give the proper gear to the aides, the nurses, the personnel, such as masks, gloves, to keep the residents or the elderly protected. If they failed to provide to do additional measures of disinfectation, if they didn't do that and someone got infected by COVID due to their lack of proceduralness, I guess, there's also a claim for that. Failure to isolate at-risk residents is also something that they could be held responsible for. And then negligence, obviously any type of negligence before COVID symptoms arose. So any sort of quality care, obviously related to the residents. So that's related to COVID and obviously the situations that we've seen now. But by Florida Statute 429.28, all nursing homes and ALFs have to provide quality care and a hazard-free environment. So it's without saying that obviously if they didn't take the proper precautions to prevent their residents and obviously the elderlies that visit that home or that center from getting infected, they're obviously not following Florida statute. Some of the things that you can get compensated for, or in other words, get, you know, the damages you can receive are compensation for bodily injury. So actual injury caused to you and to your person by having infected COVID. This can also be a claim brought on by a family member on behalf of a family member. So another compensation can be for mental harm, any losses sustained from medical expenses, present or future, that you may incur based on obviously the treatment you've had to receive. And in some cases, even death. So a family member could claim benefits, even though that's not something we ever want to talk about. A family member could claim benefits based on the death of a family member of theirs that passed away due to COVID and negligence of a senior center or an ALF or a nursing home. So those are some of the things that you should be on the lookout for if it was something that you or a family member or someone you know has been exposed to. Obviously, they have a recourse in the law. At this time, there is a recourse in the law, but policy in the future of the state legislature, state senate, or local officials pass policy or a law that gives further immunity to nursing homes, that's something that you should be on the lookout for, because the law may change, which is why I always recommend for someone in this situation to hire an attorney, in this case, personal injury attorney, which would tackle any sort of negligent cases. So I think that pretty much wraps it up. I don't know if there's any questions in particular that may need to get addressed.
Does anybody have any questions for Attorney Potestad? Okay, Attorney Potestad, can you please give your phone number so if anybody wants to contact you?
Sure. So my phone number is 305-403-4422. Or my cell phone, it's 786-569-8085, and you can contact me in either. And obviously I can help with whatever personal injury or real estate matters you might have. Thank you.
Thank you. So next we have.
Hello, excuse me. She mentioned at the beginning, Viviana mentioned at the beginning that she's also in real estate. Are we going to have another attorney in real estate?
Yes, that's actually a good, your question's perfect because Attorney De La Barra is going to talk to us about real estate and something you guys should definitely tune in with regards to his talk on Lady Bird.
Okay, thank you.
Attorney De La Barra, the floor is yours.
Thank you, Stephanie. And I just want to take a moment to thank Lorenzo for inviting me to speak with you all tonight and to the town of Miami Lakes for setting this up. My name is Francisco Leon de la Barra. I'm a partner at a small law firm in Coral Gables. And I'm just going to talk to you a little bit about real estate in general and more specifically Lady Bird deeds in quotes. Real estate transactions in general, when it comes to probate, can be complex depending on the probate process as a whole. As Attorney Lourdes Corvo and Stephanie mentioned, the probate process can be quite lengthy. And if the only asset is real property, Lady Bird deeds specifically is a very useful tool that can be used to avoid probate and the headaches and expense and really the time that can be associated with probate, and seamlessly transfer title from yourself to your heirs, whoever those might be. So we'll start off with what is a deed. A deed, very simply, is what transfers the title or the ownership in real property to another individual or set of individuals. There's two types of deeds that I guess can be used from an estate planning standpoint. One is a simple life estate deed, and the other is the enhanced life estate deed. The enhanced life estate deed is what is maybe more commonly known as a Lady Bird deed. It's based on common law, so outside of the general statutory requirements that deal with transfers of real property, there's nothing really that governs it on point. It does have some tremendous benefits. Some of the benefits include you can retain the life tenant can retain homestead tax and creditor exemptions. They can live in the property and retain all the benefits of property ownership. They can rent the property or they can sell the property without the consent of the remaindermen, which are the beneficiaries. And like I mentioned before, you can avoid probate upon the death of the life tenant or life tenants. The property would immediately transfer to the remaindermen outside of having to go through probate. So who could benefit from using a Lady Bird deed? Anyone who wants to avoid probate, anyone that has limited assets, that maybe the property that they live in is the only asset they have. And so there's no need for maybe a trust that can be expensive, things like that. To explain a little bit more about what an enhanced life estate deed is, it's the transfer of a deed where me, like my property, if I own property and I want to do an enhanced life estate deed, I would be the grantor. I'm granting the property to someone else. Typically the grantee, so the person receiving the property, would be myself as the life tenant. And then as a remainderman, I would designate my siblings, my children, so on and so forth, whoever it is I wanted the property to go to upon my death. And what that does is that I retain the ability to do with the property what I please. What does that mean? I can sell it if I want to. I can mortgage the property if I want to. I can rent it if I want to, all without needing to involve the remaindermen, the beneficiaries. That's one of the ways it differs from a plain, let's call it a plain life estate deed, which is that in a regular life estate deed, you would need to involve those remaindermen because they have an interest in the property before your death. And so if you need to mortgage a property or rent it or sell it, you would need to involve them in that process and they would need to sign the deed. Whereas with the life estate, enhanced life estate deed, you kind of strip that away from the remaindermen and you can do that without needing to involve them. It's still very much your property while you are alive. Just to touch on, there are some limitations. I don't think using this as a tool without consulting with the proper attorneys, which would be the trust and estates attorneys, who can better guide you and determine whether or not a more substantive estate planning vehicle or tool would be necessary. It does come with some limitations. Some of the limitations that not necessarily limitations, but things you might want to consider is, if the remainderman is likely to be a minor child, then at your death, then a guardianship would need to be established to be able to administer the minor's interest in real property. Same goes with if the remainderman is at all likely to be disabled in any way at the time of the life tenant's death, then the same thing. It would need to have a guardianship established to administer the interest in the property. There is another consideration, which is receipt of property by a disabled beneficiary or an elderly beneficiary who receives Medicaid benefits. It may disqualify them from receiving further benefits if they're an owner of the property. So that's something to consider as well. And the last one is estates sometimes become, or probate sometimes becomes a problem, like Ms. Corbo was saying with the 10-year estate she had, which is when not everyone gets along. It could be a problem because if you have 3 or 4 individuals who own this property, it might cause a stalemate in terms of, what do we do with this property? How do we sell it? Do we rent it? And it can cause eventually a forced sale of the property, which might be under less than ideal terms. And those are just a few of the things to consider if you're planning on using an enhanced life estate deed as a tool. It's very useful, but it does have its drawbacks, and it's not a one size fits all. So with that, I leave you all to ask any questions you might have, and I invite you to give me a call if you would like to. Our office line is 305-665-3400, and my extension is 103, and I will put that in the chat as well.
Attorney De La Barra, thank you for those kind words. Thank you for your phenomenal presentation and for helping us out tonight. We do have one question, and it's from Ms. Naranjo, and it's can ladybird deed be done even if the property is not fully paid?
So the short answer is no. When you have a mortgage on the property because it's not fully paid, there's usually a clause in the mortgage that is a due on sale clause or a no transfer clause. Basically, while there's a mortgage in place, you cannot transfer title out of your name. And so I think the short answer is probably not a good idea to do that. Longer answer is, depending on who the lender is, you could always ask. But if it's a national, like an institutional lender, it might be outside of their comprehension, let's say.
Does anybody else have any questions for Mr. De La Barra?
I'm not sure if I need to speak with him or whether you're going to have another attorney, but my question is regarding a property that is leased and the individual is not paying and I want to sell it. Do I have to evict? I know there is eviction hold right now. So that was my question. I don't know if this Francisco De La Barra is supposed to answer that or another attorney.
Sure.
So the answer is you'd have to evict them, unless the buyer wants to go ahead and purchase a property with that tenant still in there. That's a possibility as well. But yeah, you would have to evict them, because oftentimes in any real estate transaction that's residential in nature and not commercial, the person buying wants the property without a tenant in there.
Okay, thank you.
Okay. Do we have any additional questions for Mr. de la Barra? All right. Thank you so much for helping us out. And we'll move on to our next presenter. Our next presenter is also another past president of the Miami Lakes Bar Association. She is a good friend and a great attorney, and she's going to talk to us a little bit about third-party insurance claims, and that's Miss Audrey Polo. Ms. Polo? Okay, I think we're having a little bit of technical difficulties. Audrey?
I'm going to try to unmute her, sir. Just give me 1 second there. Let me see if I can.
Okay. If not, we can move to the next speaker, Brandon, and then come back to Audrey.
Yeah, please proceed, and I'll see if I can fix it for her, right?
Okay.
Thank you, sir.
The next speaker would be another, and I'm not sure if she's on the phone. Is Magda Kupris on the line? Okay, so we're going to move to, and I'd like to welcome this person. She is a Miami Lakes native. She is a wonderful attorney, and she is a wonderful addition to our judiciary. She was just won a contested election to become our new judge here, Ms. Carmen Cavarga. I'm sorry, Judge Carmen Cavarga.
Okay, here we go. Thank you very much for that. I feel like I'm amongst family. Truth be told, I have not practiced in probate for, I would like to say maybe 12 to 13 years. When I did practice in probate, I did what Attorney Enriquez was speaking about. It was, I worked for the guardianship program of Dade County, and we were the professional guardian appointed by the court for those persons that were declared incapacitated. And it could be a plenary or a limited, and they did not have the money or family members for a professional guardian. Now, the way these cases come into the court system is the same way they come in for the child abuse cases. Most of these cases are elder abuse cases, and these are persons who don't have anybody, any family members. As they, grow older, their friends and family pass on, and sometimes it's physical abuse, and it could be at the hands of an institution, such as a nursing home. You see the decubitus ulcers or things like that. You also can have physical abuse still in a room they might be renting. You get a lot of deplorable living conditions, which would be negligence. And you get a financial. A lot of times by the time we got them, financials were gone. They were depleted. And at that point, family members or friends also disappear. But, the 1-800-96 abuse is the number to call if you encounter anything that you think is like that, whether if you're visiting clients or you have family or friends or think, just someone would go out there. It doesn't mean that anything's going to happen, but at least they will look at the situation. As a community, one thing that we can do is pay attention, some attention to our elderly and visit. And the reason I talk about this is because what I'm supposed to talk about is access to the judicial system in this arena. Now, I'm supposed to talk about access as a view from the bench. The only view I can give you right now would be the park bench, because I have not really been sworn in yet. So I'm not starting till January. But access is something that I really spoke about. And some of you maybe heard me during the time that I was campaigning, especially when it comes to these matters, which would be guardianships, wills, advanced directives, the healthcare surrogates. These are things that everyday people need. These are not necessarily things that because you have a large corporation, now you're in need of it. And again, access, you know, I wish that we would, you know, I don't know if even this is appropriate now that I have this judge-elect title. But, you know, you want to make sure that people with limited funds are able to acquire what they need. And sometimes, you know, the forms are simple. And sometimes, you know, things could get a little more complicated if family members disagree and so on. But like Mr. Enriquez was saying, and I think Ms. Corvo touched on this, if family members disagree, that gets very complicated. And so you want to have these documents prepared before, you know, the durable power of attorney, before someone starts having those issues where they actually need to have these documents come into play. And that salvages many familial relationships. Many brothers and sisters, sisters and sisters, brothers and brothers, I have seen go down a very poor path because they don't have these things set in place. So access as attorneys, you know, any pro bono work that is possible. And I know that all of you here just do so much work already for the voluntary bars and so on. But sometimes maybe getting out into the community and just speaking about exactly what we are here, what things need and are available, and what forms are there to, and maybe needed to be taken care of. So that's all I have for right now. Again, I did probate a few years ago, quite a few years ago. And like Mr. Enriquez was saying, it's, you know, it could be limited or plenary, and it has to do also, sometimes you have, I work with youth now, and sometimes when they're aging out of the system, it's a very big deal because you now have, you know, the system has gotten a lot better at bridging that gap between a child turning 18 and being no longer having a legal custodian to, you know, transitioning into the probate system where they need to have a guardian appointed. You know, if there's an emergency before that, and who's going to take care of this adult now, the courts have gotten, the dependency courts and probate courts have gotten a lot better at communicating and narrowing, you know, that time period. Because yes, a lot of times it could be a mental disability. It could be, you know, different incapacities that are not exactly just for seniors. I don't know if you have any questions for me.
Thank you very much, Judge, for participating with us. And I don't know if anybody has any questions of Judge Cabarga. Judge, and you're going to be on the bench, so obviously you can't give your telephone number and ask people to ask you for advice, but someone who feels that a friend is being exploited, or someone that feels that they have someone who is sick and may need to seek the help of an attorney, what would you suggest for that person to do?
I suggest they do call the abuse hotline. And I say that a little bit firmer than I do with child abuse, right? Sometimes, you know, as a defense attorney sometimes, or even just regularly in the community, it's hard when you get the state involved, right? Things really escalate sometimes quickly. But when it comes to a senior, call the abuse hotline, because there's not a better, that is a great actual tool when it comes to seniors, because a lot of times there are family members involved and you're not going to be able to get to the bottom of it by speaking to one family member, because another family member has another story, and so on and so on. If it's an institution, they're not going to give you information. They can't by law. However, they will give that to the Department of Children and Families. So I think that 1-800-96-ABUSE is the number to call. Someone will go out there and make sure that this person is not being exploited and is being taken care of.
Thank you, Your Honor. If there's not any more questions for Judge Cavarga, we'll move on to our next speaker.
Lorenzo, I see somebody has their hands up.
Okay.
You can go ahead and speak, Ms. Bell.
Go ahead.
If it's Ms. Bell, I think she's muted.
Ms. Bell? Okay.
Lorenzo,
Well,
you can proceed.
All right. What we'll try to do, Brandon, is we'll have, after all the speakers have spoken, if anybody has any general questions of anyone, we'll open up the floor. Let me go ahead and introduce our next speaker. Thank you very much, Your Honor. Again,
Thank you.
The next speaker is our great friend, past president of the Miami Lakes Bar Association. And I think she's on, Miss Audrey, a good friend, Miss Audrey Polo. Ms. Polo?
Hi, yes. Good evening, everybody. My name is Audrey Polo. I'm so sorry for my technical difficulties. It would be the internet gods would disconnect me as soon as it's my turn to speak, of course. But thank you, Lorenzo, for the invitation to speak here tonight and for the town. I've been participating in this event. I think this is year 3 or 4, and it's always a pleasure. So thank you. So tonight I'm going to be chatting with you. I am an insurance litigation attorney. And what that means is I represent homeowners, like a lot of you, against insurance companies when they deny, they delay, they underpay your claims. So I like to think of this as a little bit more lively, right? I love what I do because at the end of the day, nobody goes to jail, nobody dies. And I just get to help people navigate a process that's very convoluted that not a lot of us understand. So today I just want to take a few minutes to talk a little bit about insurance coverage for our homes, right? I know that we, especially now that we're in hurricane season, we often think that the only thing that can really happen to our house is a hurricane. And that's the only time that we kind of think about our policies. But I encourage you to find your policies, to locate them. You have no idea how many folks, I come across that have no idea like who insures their home. They get their policy when they first get their home, or they renew it yearly, and it's kind of an automatic process. And they don't really know what they're covered for. So I'm gonna give you homework tonight, right? I want you to find your policies and I want you to take a look at them. Maybe not the whole thing, right? Usually there's a lot of good information in the first couple of pages. So forget about the legal mumbo jumbo and the 50 pages. It's this huge packet that they give you, right? I want you to focus on your coverages, right? And so you're gonna see it's kind of a little bit of an alphabet. It's gonna tell you about coverage A, and that's your dwelling. Your policy, I want you to look at it as a contract between you and the insurance company. And that's exactly, and like every contract, there's duties, there's obligations, there's things that you should be doing as a homeowner, and there's things that the insurance companies should be doing to meet their end of the bargain, right? So the first thing I want to talk to you is just about the types of things that you should be covered for. You want to make sure you have coverage A, your dwelling, right? That's your structure, your walls, that those things are covered in the event something happens to your house. You have coverage B, which is other structures. If you have a pool, if you have a pergola outside your house, things that are on your property but not attached to your structure.
Coverage C, your personal belongings, your personal property. I always tell my clients, if I were to flip your house upside down and shake it, everything that falls down is your personal property. Those are things that are dear and near to your heart. You want to protect those things. And then coverage D, it's additional living expenses or loss of use, right? Let's say that, God forbid, your kitchen burns down and now we have to eat out every day. You lost the use of your kitchen. These are things that your policy has coverage for and should cover. There's mold coverages that you should have. I want you to take a look at your deductibles. Sometimes people think, oh, I got such a good premium, you know, the price is really low. That's generally accompanied with a really, really, really high deductible and a lot of limitations. So I want you to take a look at that. Your deductible for regular things that can happen to your house should range between $1,000 and $2,500. If it's more than that, kind of a red flag. Your hurricane deductibles should be about 2% of your coverage A. 5% is really, really high. And you want to keep those deductibles as low as possible. One of the things that I want you to kind of beware of is a lot of newer policies have a lot of caps, right? They limit your damages. So a lot of new policies will have a $10,000 water limit cap. That is something you want to stay away from, right? Because water losses are the most common things that can happen to our homes. And we definitely don't want to be capped at 10,000 in that range. And we want to beware a little bit with this. It's called the Managed Repair Program. And what that is some insurance companies essentially have this program where they say, this is a loss we're going to cover, but we're going to send our folks to fix everything for you. That sometimes can be a little bit of a nightmare for homeowners. So I caution you, if your policy has those things, just to kind of consult someone and see if that's the best option for you. So in addition to hurricanes, right, we can have, your home can suffer a fire. Your policies cover vandalism, roof leaks, any plumbing breaks, theft. Any of those things are, should be covered in your policy, okay? Talked a little bit about duties and obligations, right? So as a homeowner, we don't want to treat our policies. Your insurance policy is designed to protect you against things that happen suddenly, right? You're on vacation, you come back, you open your front door and you're walking into water, a pipe burst. A hurricane happened, things that happen suddenly. It is not designed to cover things that happen over time, like wear and tear, things that you should be taking care of, as a homeowner, right? So you have a duty to timely notify the carriers if something happens to your home, right? So if something happened to you after a hurricane, don't wait 3 years to call your insurance company. Ironically, the law gives you 5 years to do that, but there's a lot of issues when you wait that long to report things to the carrier, because then they want to deny your claim for you not timely doing this, okay? You have a duty to mitigate your damages. While we are waiting for the insurance companies, we have to act as homeowners, right? We have to protect our homes. So whether that means doing it the good old Cuban way and getting a bucket and a mop and putting it under the leak, that's protecting your property. Whether that means getting every towel you have in your house and putting it on the floor, whether that means calling a water mitigation company to come out and bring machines and extract water from your property, you're protecting your home, okay? You have a duty to do that as a homeowner. And by the same token, the insurance company has an obligation. They have an obligation to timely investigate your claim. They have to send somebody to your house to review the damages, to look at them and make payment or deny your claim timely. And so, I always tell folks that I don't cut my own hair, right? Because that would just be disastrous. So I go to the hair salon, and I don't pull out my own teeth because that would be a nightmare. So we go to the dentist. So I urge you not to litigate your own claims against the insurance company. I always say this when people talk to me, I always say, State Farm is not a good neighbor. You are not in good hands with Allstate, and Nationwide is not on your side. So if your claims have been denied or underpaid, you don't have to take no for an answer. Don't get that letter with legal mumbo jumbo and put it in a drawer and hope for the best. You have insurance for a reason. So at least consult with an attorney. The best part of me is that I'm free. And what does that mean? It means that there's a Florida statute, 627.428, that says that if you have to hire an attorney because they denied or underpaid your claim and we win, then the insurance company is on the hook to pay my fees and costs. So nothing comes out of your pocket, and it's really, really important that you don't do this alone. This is, so I just encourage you to have someone guide you through the process, because something that may seem, kind of easy and routine. And I think historically, attorneys weren't really part of this process, right? Historically, you picked up the phone, you called your insurance company, they sent someone out and they paid. And I think that those days are just kind of gone, which is why there's so much legalities and things like that in this area. So again, my name is Audrey Polo. Pleasure being here tonight. And if you have any questions regarding your homeowner's insurance policy, I'm happy to help.
Audrey, can you give your phone number, please?
Absolutely. My office number is 305-444-3000. And if you prefer to reach me directly on my cell, it's 786-367-6236.
Does anybody have any questions for Attorney Polo? Okay, if there's no questions, then we're gonna go to our last speaker for the night, Attorney Magda Kupris. Did I say that correctly? Magda, unmute yourself.
Thank you. Talking to myself. Yes, you did. You said that correctly. Thank you.
Okay, so tonight you're going to be talking a little bit about residency, citizenship, immigration issues.
Yes.
Okay, the floor is yours.
Perfect. So my name is Magda Kupris, and first of all, I want to thank Lorenzo for having me on this panel today. And thank you all. I am an immigration attorney and have been an immigration attorney for almost 20 years. And I have wanted to come onto this panel because I don't know how many of you are aware, but there's two issues currently I think that are really important. And one is that it's election year. And so because it's election year, only US citizens obviously can vote in US elections. And so it's very important for anyone that's not a US citizen for them to apply to become a US citizen if you're interested in voting. There's still time to apply for citizenship. During election year, normally citizenships are being processed very quickly. And there's tend to be less barriers to citizenship applications during election years. The benefits of being a US citizen other than voting is that you cannot be deported. You have a US passport, and there are certain federal benefits that are only available to US citizens that you can obtain. Also, you can apply for relatives, such as children, spouses, parents. And if you receive federal benefits, such as Social Security, you can receive those as a US citizen, regardless of whether you live in the United States or not. As opposed to if you are not a US citizen, you can only receive those benefits while living in the United States. The other reason that, or the other issue that I wanted to raise during this panel is that immigration fees are about to go up. So right now, citizenship fees, if you want to apply for citizenship, it costs $640, the filing fee. As of October 2nd, in about a month exactly, the citizenship filing fee will be $1,170. So it's almost doubling, and there are no fee reductions for senior citizens. There are fee waivers that are available. However, they're very difficult to obtain. An individual, in order to obtain a fee waiver, has to fill out a very extensive form, has to provide tax returns, has to provide ownership of any property and they're pretty much routinely being denied. It's very, very difficult to obtain. Therefore, if somebody wants to apply for citizenship, I encourage them to do that before October 2nd of this year. So in the next 3 or 4 weeks. Finally, the steps to obtain citizenship, they're pretty easy. The form can be downloaded online from www.uscis.gov. The form name is N400. The process is that you fill out the form and it can be done online. Once the form is filled out and the fee is paid, you will get notice that the form was received by USCIS. You will be given a biometrics appointment, which is a fingerprint appointment that you will have to go to. And those locations are open. They're not actually USCIS, they're contractor offices, so they are open. You will have to go. And once your biometrics clear, your fingerprints clear, you will be set up for an appointment to take a test for your civics and for your language. For senior citizens, and this is kind of funny, I guess, but for senior citizens, there are language exemptions, meaning that if your English is not perfect, you could still pass the citizenship test depending on your age. There are exemptions for individuals starting with 50 years. And I say that's funny because 50, I don't really consider senior citizens, but to USCIS, starting 50, you're considered a senior citizen, and you may be eligible for language exemption. So you may be able to do your language test or your naturalization test in whatever your native language is. I think that there's also a civics exemption. If you're over 65 years old, the civics exam is only 6 questions versus if you're applying for naturalization or citizenship and you don't apply for the civics exemption, you will have to study 100 questions and you may be asked 10 questions out of 100, as opposed to as a senior citizen, you only have to study 10 questions and you only will be asked 6 out of those 10 questions. So it makes it a lot easier to obtain citizenship as a senior citizen. I think that's pretty much all I have to say unless anybody has questions.
Attorney Cooper, can you please give your phone number?
Absolutely. My phone number is 305-924-1133.
If anybody has any questions for her. Nobody has any, oh, no, sorry, go ahead.
Everybody's already a U.S. citizen, which is great.
Okay, so right now we're opening the floor, I guess, for general questions. If anybody is interested in asking us a question in general to anybody that spoke tonight, we are all ears for you. I think everybody's done for tonight. Okay, guys, so you have a question, anybody?
I said I think everybody's just tired.
Yeah. All right, well, Lorenzo had to, he's on Ocaraza tonight if anybody wants to pop in and watch him. I'm the impromptu moderator, but if there's no other questions tonight, then I think we're good. We're done for today, and I thank you all so much for spending time educating the public on all these really important issues. So thank you so much.
Thank you for holding the forum. It was very informative.
Yes, thank you for having us.
Thank you.
Thank you for having us. For sure.
Have a great night.
Thank you.
Thank you for
Have a
organizing.
good night, everyone.
Have a good night.